Assalamualaikum to Dr. Haji Muhammad Shanawi. My name is Raja Nadia MAISARAH binti Raja Razaruddin. In this video, I would like to present my cybersecurity case, Law of Review, Rose HANIDA binti Long versus Pendakwa RAYA. Let's start with facts of the case. The appellant is Rose HANIDA, who worked as a secretary to Ong Eng Bin, the head of corporate banking at OCBC Bank Malaysia. How this case was discovered is when one of the cost analysts identified that the business banking department that led by Ong and Bin had actually exceeded their allocated budget. So from there, the investigation was initiated to trace the source of this overspending by the department. It was found that Rose HANIDA has violated Section 4, Subsection 1 of the Computer Crimes Act, 1997. What she did was, first, she accessed the OCBC's internal system called Oracle without any authorization. Then she used the login credentials of her own boss, which is Ong Eng Bin. After that, she made and also approved financial claims through the system itself. There is about approximately 348,294 ringgit and 81 cents transferred to her account in 160 transactions. Furthermore, Rose was charged with 26 charges under two sections, including 13 charges under Section 4, Subsection 1, Paragraph B of the Computer Crime Act 1997 and also 13 charges under Section 420 of the Penal Code. This sentencing made by the Session Court itself. Okay, moving on to the issue of the case. The main issue here is whether the High Court can use the revisionary power to revise the sentence made by the Session Court was appropriate or not. Okay, next is where this case concerns the High Court's authority and the need to actually interfere in the sentencing made by Session Court. And also the issue of whether the High Court have to be ascertained for the suitable sentence or punishment to be implemented on the appellant, since the action were very much inappropriate and receive a strong criticism from the public itself. Next is the judgment of the case. There is two courts that involved in this case. There is Session Court and also High Court. Okay, in Session Court, Rose was charged under two sections. In Section 4, Subsection 1, Paragraph B of the Computer Crime Act 1997, Rose HANIDA was given a sentence of 1 year imprisonment and 15,000 ringgit of fine for each charges. In Section 420 of the Penal Code, she received sentence of 4 years imprisonment and 5,000 ringgit of fine for each charges. So in total, Session Court has decided to sentence Rose with 4 years of imprisonment and fine of 260,000 ringgit to run concurrently. Whereas in High Court, it has been decided that Rose HANIDA was sentenced to 6 years of imprisonment for each of 26 charges and a fine of 260,000 ringgit, and all the sentences are to run concurrently. Okay, moving on to the next analysis and critique. Okay, first analysis. The High Court exercised the revisionary power has actually raised a concern whether the need of this intervention was actually necessary, because if this was initiated, meaning that before this, Session Court should have been more careful in its initial sentencing. Next, the appellant's intentional action or behavior indicate as a serious crime, while she was actually entrusted with full responsibility of secretary, not cautiously planned to commit such crimes. So this highlights not just financial loss to OCBC Bank, but also the break of trust and duty. Okay, third, Rose HANIDA faced 26 separate offences, yet only 4 years of imprisonment was enforced by the Session Court. And it seems like it's too lenient, considering that major violation often handled as a single offence in the court practices. Okay, fourth, the purpose of sentencing is to prevent offenders from relapse and dissuade others from committing the same crime. But here, due to lenient sentencing, the public may perceive that the punishment given by the session court is too light. This actually can reduces the fear of committing the same crime because they would think that the consequences are not that heavy or not that severe. Next, public trust in bank has been damaged because of the financial misconduct by its employees. This can cause public to question the bank's reliability for them to actually secure their own money in the bank. This can be reflected according to Isya Riz Ahmed and Nur Farin Abdul Rahim in 2018. When internal control are inefficient, it led to financial loss in the institution itself. Furthermore, the High Court doesn't mention any grant of compensation or recovery to OCBC's financial loss. And it seems like it's lacking of true justice because the appellant, HANIDA, only ordered to pay a fine and it is only treated as a financial penalty. Last but not least, the session court may have decided the sentencing according to appellant's circumstances. Maybe because she needs to raise a child and her husband is unemployed, but it doesn't justify her crimes because she already cautiously planned for this crime for the benefit of her own needs. So it may seem like an act of compassion by session court, but it actually weaken the enforcement of justice. Okay, next is my reference. And that's all from me. Thank you very much, Doctor, for watching my presentation.